Hello my friends, today we discuss what is an international commercial arbitration under Indian law. The Indian law is provided under section 21F of the Arbitration and Conciliation Act, which provides for the definition of what can be termed as an international commercial arbitration. The first leg of that definition requires the legal relationship or the contract to be of a nature which can be termed as commercial under Indian law. Once that is satisfied, then we go into the next set of criterions that one of the parties to the arbitration may be an individual who is a citizen or a resident of a country outside India, maybe the government of another country, or maybe a body corporate, that is basically a company incorporated outside India, or any kind of other associations or legal entities which are placed outside India, located outside India. So, if any of these four formulations, one of the parties falls into that, then the arbitration will be termed as an international commercial arbitration, irrespective of the fact that the major parties may be Indian, irrespective of the fact that all the work may have happened in India, irrespective of the fact that otherwise it may just be termed as a domestic proceeding. But the legislature, in all its wisdom, has thought that it should be better, it would be served better to make these all such contracts, all such agreements, that is arbitration agreements, where one of the parties is not Indian, so to say, as international commercial arbitration. Now, but this definition does bring some kind of a legal effect otherwise, and specifically in getting any kind of legal remedies for Indian parties. Usually what happens when there is an arbitration clause between other general Indian parties, then if you want to invoke that arbitration clause and the other party is not agreeing to arbitration, you would make an application before the High Court of the state where it is situated. Otherwise, then that High Court would adjudicate and appoint an arbitrator. However, this does not happen in case of an arbitration which is termed as an international commercial arbitration. Then parties have to travel from the length and breadth of India to Delhi, to the Supreme Court, to get an appointment of the arbitrator. Now, this has a lot of problems, because this also shows one thing, for one, that the cost of litigation goes high up. It goes out from the venture of being something which is there in a particular state where the subject matter of the dispute is situate, where otherwise what would have happened is somebody from the state or a ex-judge of the state would have been appointed, like in Kolkata, somebody from the High Court at Calcutta would have been appointed an ex-judge, otherwise, which will not be the case now, because usually what happens is that once it goes to Delhi, to the Supreme Court, then somebody else is appointed who may or may not be aware of the local conditions, which I think is something to really look into. I do not understand why is the legislature of the view that the high courts of different states cannot look into this. Why is it that the Supreme Court has to be burdened with appointment of arbitrators in international commercial arbitrations? If the High Court can do it for its own citizens, I'm sure it can also do it for the citizens and their disputes with international parties. I really don't see how it should be changed and why it is so. It has been so for a long time. Perhaps it requires a change. Unless obviously it is something that it is believed that the High Court and the lawyers practicing there and the general bar is not in a functional capacity to take care of international arbitrations, which I am sure it is not the case. I think it is just something that has permeated over the ages and something which really needs to be changed. But otherwise, for my friends who are getting into litigations or otherwise getting into contracts, be aware of the fact that the litigation cost goes up if any of the agreements can be termed as an international commercial agreement, and goes into international commercial arbitration regime. This is something that you need to look into when you are getting into a contract, and it cannot be, and it is not subject to your stipulations in a contract. It is the law. If one of the parties is a foreign party, that is somebody who is situated outside or is registered outside, that is, then it will always be an international commercial arbitration. So keep this in mind, and thereafter make your decisions with regard to contracts. Thank you.